Good afternoon and welcome everyone to today's webinar. My name is Taylor Crowley and I'm a marketing associate here at Tully Rinckey. In this webinar, managing partner Michael Fallings and senior associate Paul Friener from our Austin, Texas office will discuss an overview of the ins and outs of retaliation in the state of Texas.
Hi, good afternoon. As Taylor said, my name is Michael Fallings. I am the managing partner here at Tully Rinckey in our Austin, Texas office. As you can see on the screen is my bio. I primarily do labor and employment on behalf of employees in the state of Texas. I also work on behalf of federal employees in the federal sector and helping them with their employment-related matters. As Taylor stated, today we'll be discussing what does retaliation mean in the state of Texas. So this webinar will focus on rights for Texas employees and not in the federal sector. Before we get into the weeds of everything, I'll turn it over to Paul to introduce himself.
Afternoon, everyone. Thanks for joining us. I'm very happy to be here talking about retaliation in Texas. It's something we do see a lot in our practice, and we're happy to share some of our insights and give people that guidance that they can kind of look into their own situation, seeing if they have a legal issue on their hands. But before I joined Tully Rinckey, I was practicing in different areas of law. I did family law, helping people with custody and divorces and adoptions. I worked with immigrants, helping them get their documentation papers for gaining citizenship or their green cards. But I eventually found my way into working on employment cases, and it was a passion of mine soon after that. During that time that I was helping a lot of people with their employment issues, they were coming to us because they felt like they didn't have a voice. And after doing that long enough, helping people with discrimination cases, helping people with maybe unemployment benefit issues or maybe being denied their wages, I realized that was my passion in this area of law, and I wanted to work with and specialize in that area. And that's when I joined Tully Rinckey earlier this year. And since I've been here, I've helped on a multitude of cases from the federal level and at the Texas level, helping people fight for their rights to their equal pay, helping people battle discrimination and retaliation lawsuits, including going through the EEOC process for litigating those issues. So we're here to talk about what we've learned, give you guys an overview of the law, and hopefully you'll be able to take away a lot of this information and look at your own situations.
Okay, thank you, Paul. So what we're going to be discussing today is retaliation in Texas and what that means. Specifically, we'll talk about what the definition of retaliation is. And this is retaliation in the employment context for employees in their employment. So we'll talk also about what Texas laws govern retaliation in the employment context, what laws apply, how to utilize those laws. We'll cover all that. We'll talk about how to prove retaliation. What is the burden of proof? What evidence do you need? What elements do you need to meet? How do you prove it? That will be discussed. If you're filing a claim or filing a charge, we'll talk about, what you need to use to prove that you've been retaliated against by your employer. We'll also talk about where to file claims of retaliation if you're an employee, what agencies to file with, where to file those retaliation claims, when to file them, what's needed when you file those retaliation claims. We'll talk about all that during today's presentation, as far as submitting a retaliation claim. And finally, we'll talk about, what can you receive through filing a retaliation claim? What remedies, what potential remedies could you receive from filing a retaliation claim? What can you be awarded through your retaliation claims by an agency or your employer? We'll cover all that towards the end of our presentation as well. So to go ahead and get started with the next slide, retaliation defined. What is retaliation? in the traditional sense, in the most basic sense, retaliation is when an action is taken by an employer following an employee engaging in protected activity. So let's kind of break that down. Protected activity, what is that by an employee? Well, protected activity is when an employee participates or opposes discrimination. Okay, so participation, what does that mean? Participates in protected activity. Participation could mean that an employee is filing a complaint, or participating as a witness in a complaint. For example, if a coworker files a complaint about discrimination and you are named as a witness, you're participating as a witness. That is still protected activity, even if you're not filing the complaint. Opposing discrimination in the workplace is also protected activity. What's key here is that you don't necessarily need to file a complaint to oppose discrimination in the workplace. And when I say file, that normally means submitting a formalized letter or written correspondence to HR or a supervisor regarding the complaint. Well, protected activity is actually broader than that. If you complain even verbally to an employer regarding discrimination in the workplace, that could be considered protected activity. As long as you're expressing that you're opposed to the discrimination in the workplace, that could be considered protected activity. And I'll further break that down. So when I say opposing discrimination or participating in a discrimination complaint, we're talking about discrimination in the workplace, meaning an individual is being treated differently based on a protected category. Protected categories under the law include race, sex, national origin, religion, color, disability, and there may be some other categories, and I'm not completing, but there are similar categories like that are categories where individuals cannot be treated differently. So if you are saying that you believe that you've been treated differently or someone else has been treated differently, that is protected activity. If you're named as a witness to somebody being treated differently, you're in a protected activity. Now, what does protected mean? That means that if you engage in that, if you're participating or complaining, then you're protected from retaliation. You're protected from an action taken against you because you engaged in that protected activity. So if you complain against a harasser in the workplace and you complain because you believe that harasser is discriminating against you, the employer cannot then take an adverse employment action because you complained. So an adverse employment action could be considered a termination or a demotion or suspension, something that impacts the terms and conditions of your employment. However, in the retaliation context, it's even broader than that. It doesn't even necessarily need to be a termination or a demotion or something that affects your pay. In the retaliation context, it's called a material adverse action. And why it's broader, it's an action that would deter a reasonable employee from complaining about discrimination. If an employer takes an action that would deter you from continuing on complaint. For example, if an employer gives you notice that they are considering terminating you, a proposed termination, that could be considered a material adverse action. A counseling that's not necessarily impacting your pay or benefits, a letter of counseling, that could be considered a material adverse action. Okay, so if you complain and then soon thereafter you receive an action that's not to your liking, that's against your interests, it could be considered an adverse action that's the employer is trying to deter you from continuing on a complaint. And this is common because employers or supervisors, when they receive complaints against them, they naturally are not wanting that to deal with that complaint. They're probably a little bit upset. So it's important for you to know that it doesn't have to be that you're terminated or demoted or suspended. It's a material adverse action. That's an action that would deter a reasonable employee from continuing on with a complaint or even complaining. Um, Now, the other element or part of the definition of retaliation that's also important is that there has to be a motive, and there has to be causation. And we'll talk about this a little bit further, but as far as the motive or causation for an employer to take that adverse action to establish retaliation, that action typically has to be close in time. If you filed a complaint with your human resources department or your management, and then 2 years later you receive some adverse action, the courts will likely not view that as sufficient causation because too much time has lapsed. You would have to prove why that amount of time should be disregarded. But most cases have found that really it has to be a couple months, a short amount of time between the complaint and the adverse action. A key thing to note here is that it's the time frame between when the employer became aware of the complaint and the adverse action. So if you complained, let's just say you complained in 2020 about discrimination, but your supervisor didn't find out until 2023, and once that supervisor found out, then they took the adverse employment action, then you could still establish retaliation in that part because the employer didn't find out about your complaint until 2 years later, and then soon after the employer found out, that's when the adverse action happened. And so if you're able to establish that short amount of time between your complaint and the adverse action, you'll be able to help establish that motive that we have here on the screen as far as establishing what retaliation is. We'll move on to the next slide to talk about the laws that cover retaliation in the employment context. So we have a list of statutes here on our screen. Primarily, what covers retaliation in the employment context is that Title VII of the Civil Rights Act and the Texas Labor Code, Title II, Chapter 21. These laws prohibit discrimination and retaliation. So as stated on our screen here, these laws prohibit discrimination based on race, color, religion, national origin, sex, but they also prohibit retaliation when an employee complains about one of these categories, complains that they feel like they've been discriminated against based on one of these categories. So those laws apply in the employment context, and those laws are the laws that are primarily used. But we also have the Texas Whistleblower Act, which we have done prior webinars on. But for here, it's important to know that the Texas Whistleblower Act is an act that protects against retaliation. As noted here, it protects public employees. Here in Texas, it does only protect public employees, such as state and government entities. And for the Whistleblower Act, this is beyond actually the discrimination. This covers the reporting violations of law, rule or regulation, fraud, waste, and abuse. These are actions that employees are taking when they believe that there is fraud, waste, and abuse or violations of law, and they make those complaints to their employers. Well, they're protected under the Texas Whistleblower Act from retaliation from making those complaints. We also have the Age Discrimination in Employment Act, which protects against retaliation for complaints made on age. So if you have made a complaint based on discrimination based on age, the ADEA, the Age Discrimination in Employment Act, could protect you from retaliation. Similarly, the ADA, the Americans with Disabilities Act, which Texas law does apply as well, prohibits retaliation for employees that are complaining about discrimination. To note here is that The ADA, the Americans with Disabilities Act, allows a request for a reasonable accommodation to qualify as protected activity. So if you have requested a reasonable accommodation for to perform your job, such as you're requesting to telework because of your disability, you are now protected from retaliation based on that request for reasonable accommodation. So if an employer takes an action against you because you requested a reasonable accommodation, even if that accommodation is approved, you could still seek to establish that you've been retaliated against because you have requested or engaging in the reasonable accommodation process. Next, here we have the Family and Medical Leave Act. This act provides coverage and allows employees to take leave for a qualified reason. And it allows employees continuation of their benefits and allows them to have a restoration to their same or equivalent position. Now, in the retaliation context, this means that employers cannot retaliate against employees that have engaged in the FMLA, the Family Medical Leave Act. And so if an employee has taken FMLA or even requested it, and an employer interferes with or retaliates, an employee could claim retaliation. Notable here is that the FMLA is somewhat different than the Title VII and some of these other laws, is that they don't have a requirement to go to the EEOC or to exhaust what they call administrative remedies. You could file those types of claims in court under the FMLA. And lastly here, the Genetic Information Non-Discrimination Act, GINA, prohibits discrimination based on employee genetic information. Similarly, if you make a complaint under this act and the employer takes actions against you because of your complaint, the employer could be found to have been retaliating against you. It's just important to know that there are certain elements that you have to meet, as I did discuss, and the employers do have a right to challenge you meeting those elements, meaning they have a right to challenge that you engage in protected activity, they have a right to challenge that there was any adverse action against you, and the employers do have a right to establish that they take those actions because of a legitimate reason, which you would then have to prove that those were not legitimate and that the real reason was retaliatory. So it's ultimately will be up for a court or an agency to decide, but these are the laws that you would be able to utilize to prove the retaliation in the employment context. Let's see. Well, I will now turn it over to Paul Friener to discuss our next slide here.
Thanks, Mike. So remember what we're talking about here with retaliation. The law protects you whether you are complaining about discrimination directed at you or some type of activity that you've engaged in that you've been retaliated against and you've noticed it in the workplace. But also if you're seeing it happening to other individuals and you're opposing that type of retaliation that's connected to some type of discriminatory behavior that was complained of. These laws are there to protect the employees in the workplace, and without applying them and using them to help provide you that stability in the workplace, then they're just a piece of paper. So it's good to always keep those in mind in the way that you look at what's fairness in the workplace. But when you find yourself in litigation, or you find yourself kind of making that consideration, do I have enough in my case to bring a claim? Is there enough evidence that I can point to that a judge or maybe even working out a settlement possibly with your employer that they would believe that retaliation occurred? What do you look at, and how do you kind of decide that when you're deciding whether or not you should move forward? Well, the courts and a lot of different practitioners in this area of practice, they look at two types of evidence: direct evidence and circumstantial evidence. And before getting lost in the definitions of those, there's two really simple ways to look at that. Direct evidence is, for example, if you walk outside and you see it raining, and you see the rain falling from the sky, you feel it on your skin, that's direct evidence that you believe it is raining. It's pretty clear, it's undisputed. But what happens if you walk outside and it's no longer raining, but there's a puddle of water all over the street, and you're trying to put together maybe it did rain, and you could tell from that surrounding circumstantial evidence by looking at a puddle of water on the street that it once rained and possibly it's raining now somewhere else. But think about retaliation and how it connects to discrimination in the same context. Most employers nowadays, they're smarter than like most people would give them credit for when it comes to retaliating. It's not going to be obvious any longer. Now that we've been litigating these cases for so long, employers are being trained on how to avoid being held liable for retaliation and discrimination. But direct evidence, while it still is rare, it can happen, and it's where an employer might admit to their employee, and some kind of apology, possibly saying, I'm sorry, I retaliated against you. You made a complaint, or you were opposing some type of issue in the workplace that relates to discrimination, and I negatively made a decision, a personnel action against you. It's not going to happen. It's a rare situation, but in certain cases it does happen. And if that does occur in your case, or maybe someone at your workplace, that is good grounds to move forward. It doesn't, clean the slate for them just because they're apologizing. That you should act on what information has been provided to you, because they're basically admitting to their intent, to their motive for why they acted the way they did when they retaliated against you in this context. Circumstantial evidence is where a lot of cases and a lot of attorneys spend time arguing in. And because it's become so complex, there is a burden shift analysis that we have to do, at least what the courts have laid out for what we do when we're trying to prove that retaliation occurred. And it's sort of in 3 steps. But the first step is that an employee needs to make a casual connection, and don't even worry about the word casual. Just think that there has to be a connection between the protected activity that the employee engaged in, such as complaining about harassment. Maybe you, as an employee, you received you've been receiving some type of harassment from your employer about your age. And they keep making comments that you work too slow, and it's probably because you're so old, and you make a complaint about that. And in response, after HR hears about this, they discipline the manager who made those comments, and now the manager is angry at you, or angry at someone that in the workplace, and then you start to see some type of retaliatory behavior. Well, you can kind of start to see the connection, because for example, if it was really close in time, as Mr. Fallings was describing, well, you can see that casual connection a lot easier. But the further it separates, further in time apart these 2 instances are, the more difficult it might be to prove that circumstantial evidence. But let's say that as an employee, you're able to prove that connection that exists between the protected activity and the materially adverse action. You've now established a prima facie case, which is just a presumption to maybe a fact finder like a judge that retaliation has occurred. So now the employer and their attorney, their job is now to rebut, to provide some type of counter argument to that stated presumption. And they're going to have to prove that the decision that they made was a business decision. It was a legitimate, non-retaliatory reason for their adverse action. A lot of employers, a lot of businesses, a lot of federal and state agencies may say that we made those decisions. It had nothing to do with that employee. It had to do with a business interest. We would have made that same decision for, if it were another person. And that's a really common counter argument that we see. It's a common defense that we always overcome when there's plenty of evidence to support that there is just kind of this very strong connection between the engaged protected activity and the retaliation. But if they are able to make that rebuttal, they are able to show at least, they are able to make the argument that we did this for a legitimate, non-retaliatory reason, then the employee must come back and basically argue in the opposite and say that, no, that was pretextual. Your decision on retaliating against me or retaliating against somebody in the workplace was really based on discriminatory intention. You weren't doing it because of a business interest. You were doing it because that employee made a complaint about the harassment that employee was receiving in that example because of their age. And so you're able to continue to hold on to that connection and continue to prove it. A court would also be able to find that that would be something that is that looks very much like retaliation in this employment context. But it's very difficult to sometimes make these circumstantial evidential arguments. The burden shifting analysis, once that became a really common procedure in the litigation process, attorneys and businesses alike, and anyone who's representing those businesses, spend a lot of time trying to go back and forth on whose position is correct. Was it a legitimate business interest decision, or was it a retaliatory decision? And so spending a lot of time, and as an employee, making sure you're able to help draw out those facts, you're kind of keeping an eye on what has happened to me in my situation, and how can I help point out these particular facts to make that connection. So we'll go to the next slide. So the most important thing after you've decided that, okay, I think I do have a case, when do you file your retaliation claim? And in Texas, it's pretty simple. It's 180 days after the last incident of the unlawful practice occurred. However, that's when you're filing with the Texas Workforce Commission Civil Rights Division. But there is a specific law at the federal level that allows that timeline to be extended to 300 days when you're filing with the EEOC. So the EEOC, the Equal Employment Opportunity Commission, is your federal agency that governs the federal discrimination laws. If you have a claim that occurred related to retaliation in Texas, you can file with the EEOC, or you can file with the Texas Workforce Commission. Filing with the EEOC allows you obviously a lot more time, but it gives you maybe more time to decide whether you have a case and kind of gather the facts of your case. If you think that maybe more information will come to light, because the minute you file that retaliation claim, the minute you get the ball rolling and the employer becomes aware of your charge of discrimination and retaliation, everything is going to change. All the evidence may start to possibly disappear. You might maybe receive further retaliation and start getting shut out of your email and access to other things that are going to help support your case. So it's always important to take that time that you need, but you have to timely file, because once you miss that deadline, you're barred from bringing an action on that particular claim of retaliation. Attorneys can make arguments for good faith instances where a filing was not done on time, and that would be something that you would want to talk with an attorney about. But they have a very strict rule at the EEOC and the Texas Workforce Commission on these timely filing deadlines. We'll go to the next slide. So potential remedies for filing for retaliation claims. I would say the most employees, if you're talking to someone who's going through this process, they are seeking monetary awards to compensate them for the loss that they've suffered as a result of their employer's action. What a lot of people don't know is that there are statutory limits, they call them caps, on how much you can recover, and it's up to $300,000. And when you're looking at the different types of damages that you can recover, when you're talking about compensatory damages, you're talking about also back wages or your lost wages. So for example, just to kind of explain what that is, back wages would be, for example, you have employee Jimmy. He works for ABC Home Improvement Supply Store, and he's terminated because he has been, not able to keep up. He's he's an older employee, and the ability to do his job as a cash register is just not up to par with what the employer is wanting. Now, Jimmy reports his manager to HR for harassing him about being an older employee because his manager has been making comments to him. And like I kind of used as my previous example, Jimmy's manager is now angry, and he takes retaliatory action against Jimmy by removing him as a cash register person, and has him now mopping the floors, and he now also lowers his pay rate based on the change in his duties. And Jimmy was making $2,000 per month before his duties changed. Now, eventually, when Jimmy's manager fired Jimmy for complaining about his new duties and his lower pay rate, it now takes Jimmy 3 months to find a new job, and he does find a new job at All Things Hardware Store. If Jimmy sued ABC Home Improvement for the lost wages, he would be entitled to $6,000 in back wages, which represents the lost pay during the 3 months he was out of work. Another category of damages that are litigated over is front pay. And front pay is typically after you enter into some type of agreement, or you go before a judge and a judgment is awarded by that judge. That time period that is occurring after that court case occurred would be, up until the time that you're able to find a new job. That would be your front pay. So it's a very subtle difference between back pay and front pay, but that's how you calculate front pay. Some other specific types of damages in this employment context are emotional pain and suffering, which again are your compensatory damages. And these are things that are often litigated over, but due to the statutory limits, we are regularly having conversations with our clients, and employees are coming to us thinking that they can have millions and millions of dollars, and based on case law and legislative action, even at the Texas level, in the Texas legislature, there are caps to prevent that. And like I said, anything that can range from up to $300,000 down to $0, but you're arguing over non-monetary remedies is possible. But you have to keep that in mind as you are trying to decide if you're going to take this case on. Is that going to be enough money to make you whole? And is that something that would allow you to, be at peace with whatever action has happened? And if you're going before a judge trying to get some kind of court order regarding a judgment for your damages, you have to consider, if this is the most I can get, is that going to be enough? But when they're looking at what is your pain and suffering, that category is really talking about psychological trauma that was endured by the employee as a result of the employer's illegal action. This is where sometimes experts come to testify about their regular treatment of possible therapy services for an employee that has had such a difficult time dealing with the actions of their employer that they are now in regular therapy, that it's impacted their lives and in all areas of their lives, and it's made it even more difficult for them to perform the duties of their job. And so as you're bringing all that information to light, you're explaining that to a judge, or maybe you're explaining that to opposing parties in some type of settlement negotiation. You're taking that in, they're taking that into consideration, and you're also using that information to support a damage award that would be anywhere in that range that we discussed. But again, generally, the more egregious, the more disturbing that the behavior was by the employer, the greater the damage award could be. And then after it, when you're discussing how egregious that damage was by the employer, and you're looking at the situation of the employer acted with so much intent, so much malicious or so much malice and reckless behavior, then you're talking with the judge possibly about punitive damages. And those are damages that are specifically categorized for punishment damages, essentially because the employer has acted in such a way that it is so horrid that that they should be punished for their actions related to that retaliation. There's also reimbursement for attorney's fees that don't get encompassed in the statutory cap. So if you're working with an attorney and you've agreed upon some fee, that amount could be reimbursed as part of your settlement or as part of an award that you would get from a judge. Once you get past all the monetary damages, the monetary awards, and whether that's inclusive in your judgment or that's inclusive in your settlement negotiation, you're talking now about non-monetary items. And non-monetary items can sometimes be easier items to get, but they should always be included in the balance of how much can you get from the monetary side, how much can you get from the non-monetary side. And so some common non-monetary items that we regularly negotiate over are restoring leave for employees. Employees often maybe want to transfer departments or have a different supervisor. Those are things that we would negotiate over if that is an available option. We often get requests for apology letters from that supervisor. Those can be difficult to get, but they're all in the realm of possibility. Asking that the management that contributed to the discrimination retaliation be trained in sensitivity or be trained on the Texas Labor Code discrimination and retaliation laws. That could be something that you could have the judge order. But non-monetary items can be very specific based on whatever your situation is and whatever may possibly help retain you as an employee of that company. If you're looking to leave that company and you want just a severance type of agreement, or you're looking to get some type of award because you have no interest in staying there any longer, then you're going to be talking more about monetary items. And if you've received some type of reprimand that was a part of that retaliation or some type of letter of counseling that is now in your employment file, you would also be asking to have that completely expunged. You would want a clean slate, and you want to be able to go to future potential employers and tell them that, yeah, you worked at this particular place and there would be no record that there were any issues. But other than that, the damages are an important part of the case itself. When you're trying to pursue a retaliation claim, it becomes part of your leverage that if you are working on entering into a settlement, you would explain to your employer, if you're represented, that we don't want to have to go to trial. We don't want to have to file a charge of discrimination, retaliation. We'd like to work out a settlement because it may be worth more to you to just work this out outside of court than spend hours of resources and money trying to defend a claim that is, at that point in time, very organized and prepared and ready to proceed. Well, Mike, I'm going to turn it back over to you. I think that's really what else all I want to say on this particular slide.
Oh, yeah, thank you. Well, I think that covers, the topics we were intending to cover for today's webinar. Lastly, we will just open it up for any questions that you may have. We'll hold, to see if we get any questions. So we received a question regarding, I think, damages and remedies. And I'll start on answering. I'll let Paul chime in with any information he could provide. But if a person complains of both the discriminatory act, then files retaliation, are there two separate caps or one combined? If it's part of the same complaint, it will be one combined. If you're saying, if the question is that you have a pending complaint and then you add to the claim a retaliation component, that doesn't double the cap. That would keep it as one cap. And if the cap we're talking about, I believe the question is referring to the compensatory damage cap, it would still keep it at one cap.
Yeah, I think that is correct. There are different scenarios where if there were multiple plaintiffs involved, each would be, held to that specific cap. So it could be, maybe in that particular scenario, a combined award that would be over the $300,000, but each plaintiff in their cause of action or in their claim are limited based on their case.
And just also to note here, the cap is related to compensatory damages. You know, other damages, I mean, in some cases, punitive damages can be awarded. You know, front pay and back pay, you know, are things that could increase, you know, monetary rewards. But, you know, if you're just one person, yes, it's just going to be one cap, no matter if you add a retaliation claim. Another question we did receive is, can retaliation and targeting be proved if it's not based on a specific class? Well, it depends on the law, but the most laws require that the complaints be based on a protected category. So, for example, under Title VII or the Texas equivalent, the complaints need to be based on discrimination. Now, that doesn't mean you have to say the magic words, discrimination. However, you need to at least be able to show or have the receiver of the complaint understand that you believe you're being treated differently because of protected category. I've seen frequent complaints dismissed when it's a complaint that's not based on a protected category. If you go to your employer and say, well, you know, I don't like, you know, this person. I think this person's treating me differently because I wear a particular type of shoe. That's not a protected category, right? Or I don't like this person because they're yelling at me. Well, that may not be enough. You have to show that, or you have to say, well, I don't like this person because, or I feel like I'm being discriminated against because of you know, how this person's treating me, or I believe my supervisor's yelling at me and not yelling at others in the similar fashion. At least saying that could help show or help prove retaliation. But if you just say, well, I think, you know, my supervisor is looking at me incorrectly, you know, that may not be enough. You have to say, well, I believe my supervisor is doing this to me because of my protected category, race, sex, whatever it is, or they're treating me differently than other people. You at least have to show to the employer that you believe you're being treated differently. And it's similar to the other laws as well, as far as the whistleblower laws or the ADA or the FMLA. You have to connect it to a protected category. Paul, do you have anything to add?
No, just to remind the person asking the question is you're always wanting to bring it back to the protected activity, which is, you know, connected to the protected class. Whatever was being engaged in, whatever protected activity that connects back to those protected classes, race, color, national origin, religion, sex, age, disability, that's being brought up, that's being complained about. That's where this is really starting. That's where the story starts. And so whatever retaliation occurs afterwards, if it's able to be connected back to those particular things, then yeah, you would have a case. But outside of that, it becomes more difficult to make a showing, or it won't even be a particular case that you could bring because it's not protection under the law. It may just be considered an employer being rude, an employer acting uncivil. But that would be something that you would want to explore with an attorney and kind of figure out if there is some different angle that maybe you're not seeing based on the experience that you've had.
That looks like those were all the questions that were submitted. But I think, like Taylor said, you know, this will be posted. And, you know, we encourage you to follow up with an attorney or with our firm, you know, for any other questions you may have. Thank you.
Thank you.